Welcome to the presentation on bona fide occupational requirement. This is the third and last of 3 webcasts describing duty to accommodate in the workplace. My name is Jessica Snow, and I will be hosting this webcast along with my colleague, Carolyn Ormsby. We are both with the Alberta Human Rights Commission. Please note that the human rights legislation referred to in this webcast is the Alberta Human Rights Act. The commission referenced is the Alberta Human Rights Commission. If you have a human rights concern with an organization that falls under federal authority, or if it falls under another provincial or territorial authority outside of Alberta, check with the federal, provincial, or territorial Human Rights Commission in that jurisdiction for more information. It's important to note that the information presented in this webcast is not legal advice. It's information to increase your understanding of the Commission's duty to accommodate process under the Alberta Human Rights Act. I will now hand this over to Carolyn.
Thanks, Jessica. This webcast will provide an understanding of what is a bona fide occupational requirement when there is a request for accommodation in the workplace. The key concepts in the duty to accommodate are areas and grounds of discrimination in the Alberta Human Rights Act, undue hardship, and bona fide occupational requirement as a defense to discrimination.
What is a bona fide occupational requirement?
A bona fide occupational requirement is a standard rule or policy that is essential to perform the duties of a specific position. For example, to perform their job safely, people employed as drivers require acceptable vision. A legally blind person would be legitimately excluded from a position as a driver since it is a bona fide occupational requirement to be able to see and to obtain a driver's license. As a result, an employer could claim that obtaining a driver's license is a bona fide occupational requirement and justifies the discrimination. Once a job requirement or policy is found to be discriminatory, the onus is on the employer to show how that job requirement or policy is essential to the job and is therefore a bona fide occupational requirement. When a complaint about a standard or policy is received by the Commission, the following questions are asked to determine whether the Commission can accept the complaint. Has the person making the complaint been subjected to a negative or adverse impact because of the standard rule or policy? Is the negative or adverse impact linked to a protected ground under the Alberta Human Rights Act? And lastly, if the answer is yes, then the Commission will accept the complaint. Once the complaint is accepted, then the employer will be asked to provide the information that its standard or policy is a bona fide occupational requirement and therefore not discriminatory.
How can the employer determine if their standard, rule, or policy is a justified bona fide occupational requirement?
The Supreme Court of Canada, in a decision in 1999, outlined a 3-part test for determining whether a standard rule or policy is justified. The Majoran test, named after the female firefighter in this case, sets out an analysis for this determination. You can read more about this case by visiting canli.org and typing Majoran in the search field. The 3 questions in the Majoran test are: 1. Is the purpose of the policy or standard rationally connected to the performance of the job? 2. Did the employer adopt the standard or policy in an honest and good faith belief that it's necessary to the job? And 3. Is the standard or policy reasonably necessary, and is it possible to accommodate the employee without creating undue hardship for the employer?
How can an employer ensure that their policy meets the Majoran test?
The answers to the following questions will assist the employer to determine if the standard rule or policy is indeed a bona fide occupational requirement. What is the purpose of the standard or policy? Is it safety, efficiency, something else? What are the objective requirements of the job? Is there a rational connection between the general purpose of the standard and the objective requirements of the job? When was the standard or policy created? By whom? Why was it created? Other questions include, what other considerations were included in the development of the standard or policy? Are there options for accommodation that could have been considered without creating undue hardship for the employer? Was the standard or policy based on assumptions about a particular group? Is there evidence that the standard or policy treats a particular group more negatively than another group without apparent justification? A few more questions include, were alternate approaches considered before the standard or policy was adopted? If alternatives were considered, why were they not adopted? Is there any evidence the standard or policy was designed to minimize the burden on those required to comply? Is it necessary for all employees to meet the standard or policy for the employer to accomplish its legitimate purpose? And lastly, is there any information that the legitimate purpose could be accomplished through a less discriminatory approach? When using the Miorin test as a defense, it's not sufficient to meet only one or two parts of the test. The employer must ensure that the standard or policy meets all three parts of the test. Each situation is unique and must be considered on a case-by-case basis. Therefore, an employer who makes a successful defense based on the Miorin test in one instance may not be able to rely on the defense in similar future cases. I'm now going to turn this back to Jessica, who will describe some of the resources that are available from the Commission.
For more information or to access our resources, please visit our website at albertahumanrights.ab.ca. The Commission has materials that can be downloaded, such as our information sheets titled Protected Areas and Grounds under the Alberta Human Rights Act, Employment, Duty to Accommodate, Obtaining and Responding to Medical Information in the Workplace, a summary for employers, and Obtaining and Responding to Medical Information in the Workplace, a summary for employees. We also have more in-depth resources, such as our human rights guides titled Duty to Accommodate Students with Disabilities in Post-Secondary Educational Institutions, Defenses to Human Rights Complaints, and lastly, Obtaining and Responding to Medical Information in the Workplace. You may wish to view our webcast on the Alberta Human Rights Act, as well as the other two webcasts in our Duty to Accommodate series. They are an overview of Duty to Accommodate and Undue Hardship. Find those and other Commission videos on our YouTube channel at youtube.com/Alberta Human Rights. You can also link to our channel from the e-learning page on the Commission's website. If you have questions on a specific situation, or if you want to determine whether you may have the basis to make a human rights complaint, please phone the Commission's confidential inquiry line. If you are north of Red Deer, call the Northern Regional Office at 780-427-7661. If you are south of or in the city of Red Deer, call the Southern Regional Office at 403-297-6571. To call those numbers toll-free within Alberta, dial 310-0000, then enter the area code and phone number. This brings us to the end of the presentation on bona fide occupational requirement. Thank you for your interest in human rights-related issues, and we hope that you will join us again for future webcasts.